This is an interview with Professor Thomas Geraghty at the Northwestern University School of Law, where he is the director of the Bluhm Legal Clinic and a well-regarded expert on issues concerning juveniles. His article in the Journal of Criminal Law and Criminology concerns Cook County criminal practice in 1929. And let's start, Tom, with you telling us what interested you about these historical cases and looking at the practice of law in 1929.
Well, I've been practicing law as well as teaching since 1970, and I've been practicing pretty much exclusively in the criminal courts at 26 in California, where the case that I studied was tried. It was actually one of the first cases that was tried in that building back in 1929. I was interested in working on this project because I've always been fascinated by some of the work of some of the lawyers who I saw when I started practicing law.
Tell us about the new criminal courthouse and the atmosphere there, and why cases were moved from the legendary criminal courthouse in the middle of downtown Chicago.
The old criminal courthouse is on Hubbard Street. Now it's occupied by one of the major law firms in Chicago. Right. It's a beautiful old building, but it became inadequate to house the burgeoning number of criminal cases, and so. And I think the other issue was that the jail population was expanding, and they needed a place where they could house both the courts and the people who were waiting trial in a location in close proximity to each other, so that you didn't have a lot of expense in transporting people from jail to court.
Would it have been standard practice for people to be sitting in jail while waiting for their trials?
Oh, absolutely, because there were so many who could not afford to make bail, and that remains the case today. When I started practicing in 1970, the only buildings out there in that area where 26 in California is now were the old criminal court building and the old Cook County Jail, which is located just to the south of where the jail is. I'm sorry, where the courthouse is. And I think there were a total of maybe 3,000 prisoners in 1970. Now the jail has expanded to the entire neighborhood where the courts at 26 in California are located. And the population of the jail is over 10,000 people waiting trial in the jail at 26 in California.
So in 1970, when you first started practicing law, it was 3,000 people waiting for trial, and now it's closer to something like 10,000.
Yeah, and it was probably a lot less than that when the court. I'd say probably 1,500 or so when the building opened back in 1929. We've also seen a tremendous increase in the number of courts in that facility. The original courthouse, I think, maybe had probably 15 or so criminal court rooms, which actually, if you go and look at them, are quite beautiful.
The old ones?
The old ones are, yeah.
Are they still used?
The old ones are still used. They carved up the first 3 floors of the building at 26 in California and made smaller courtrooms out of the larger ones, which is a real shame. Because those newer courtrooms are, I think really everybody agrees, not very workable and not very hospitable to trials. The old courtrooms, however, are large and beautiful, and one has been actually maintained in its pristine state. It's room 400, where Judge Tooman sits now. The others have been remodeled and renovated. Tragically, I think the other courtrooms, the other large courtrooms, ceilings have been painted over. There's some beautiful frescoes on the ceilings that still remain in Judge Tooman's courtroom and actually in the old grand jury room there that are really, really beautiful.
Well, that kind of ornamentation is, of course, in keeping with the idea that trials were public theaters. People stood in line, they waited to see the famous people, the defense attorney, the prosecutor, and you were in a very special, rich, opulent place where important things happened.
I think that's absolutely right. I think in a lot of ways those old courtrooms resemble churches in some ways. There are pews. I mean, the old benches resemble pews.
Exactly.
And you're absolutely right about the extent of the spectator space in those old courtrooms. Rarely now are those courtrooms filled? You know, in the case of a notorious trial, they are.
Right.
And I happen to think that even back in the 20s, it would be unlikely that they would be filled except in exceptional cases.
Some people would have wanted the jail and the courthouse removed from the city, even if it wasn't convenient for the participants.
Well, it's my understanding that the building and the court building and the jail were built in 26 in California because Mayor Cermak owned the land out there. And there was some suggestion that he might have profited from selling it to the county in order to build the building. The other reason for building the building out there, I think, was to remove it from downtown where the old courthouse was, right in the middle of downtown on Hubbard Street. Not only because Chicago wasn't particularly proud of having the need for such a building, of course, which all cities do, but for security reasons as well. It was a system which enabled the criminal defendants who were awaiting trial to be isolated from the rest of the population and to be transported very easily from the jail to court. They constructed a series of tunnels from the jail to the court so that the prisoners never had to see the light of day in getting from one place to another.
Are those tunnels still in use?
Yes. Yeah, they're in use, and as a matter of fact, I recommend a visit to the jail. You can see them, and you can see them in operation if you get a tour down in the basement. Yeah.
Let's talk about the organized crime cases and that extraordinary piece of scholarship, the Illinois Crime Survey, which you discuss in your article. One of the things that has surprised the researchers on this project is the relatively small number of organized crime cases in this data set of 11,000 cases, and we don't know why. Even if you isolate the 1920s period, you don't see a predominance of organized crime cases. They're relatively few, and we don't understand that to date.
Well, I think, in fact, I think there are two explanations for that. Number one, that indeed the proportion of organized crime cases was probably relatively small. I mean, compared to the rest of the cases, typical kinds of murders and violence that you'd have as a result of domestic situations and that kind of thing. The second point, I think, is that, as is the case even now, the state courts were not really equipped to try major organized crime cases, and that was for a number of reasons. Number one, the close ties back then that the court system had with organized crime. And number two, just the technical ability of the people in the system to handle complex criminal cases. It is still true, I think, that in Chicago, the most complicated conspiracy cases are, if there's any way to try them, they're tried in the federal courts, simply because of the capability and the talents of the people involved in the prosecution and investigation of those cases is really, I think, a step above what we have in the county system.
But isn't it true that in the 20s the federal jurisdiction wouldn't have been as extensive as it is now?
I think that's probably right. I think that, we've developed things like RICO and that kind of thing, relatively recently. But we always had the ability to try organized crime figures in federal court. Al Capone was tried there for tax evasion. But for the run-of-the-mill street crime, you're right, we still have to rely on, we couldn't rely on federal courts to handle that kind of thing back then, and we still would have to rely on state court to try them now. But even, if you take the example of the Alleman case, which was tried in the criminal courts, I think beginning in the 70s, actually, here. I don't know if you remember that case or not, but it was a case in which Harry Alleman was charged with a murder. He was initially acquitted, but evidence surfaced later on that he had paid a bribe to be acquitted. And so the state's attorney of Cook County sought to try him again. He raised a double jeopardy claim, but the Illinois Supreme Court ruled, and I think quite properly so, that you can't raise a double jeopardy claim if you're the person who procured the first mistrial or not guilty by a bribe. So that's the kind of case that actually was ongoing in the criminal courts when I started practicing. That case was, I think, first tried in the early 70s, and there was still that residual, I think, influence of the kind of culture that was in existence in 1929 when the case I studied was tried.
Let's talk more about the case that's the subject of your article and what was distinctive about it and its character.
First of all, I think it was very interesting that there was comments in the materials that I looked at that indicated that this was the second most notorious trial to the Leopold and Loeb trial that had been tried just a few years earlier, and yet it received very little. It had received no attention from scholars at all. There were a lot of newspaper articles about it. It received a lot of play in the press, and particularly the Chicago Defender. But nothing had been written on the case.
Why do you think that was?
Well, I think that I think that that's because people have not, for the most part, studied trials that were not sort of viewed as being historically significant. That did not raise political issues that were sort of readily identifiable. And I think this case, at least initially, was viewed as a case that involved 6 defendants, all of whom were black. It was a robbery, a bank robbery, and it was sort of viewed by the public, I think, and most of the prosecutors and defense lawyers even, as being sort of a case that did not raise significant social issues. The lawyers who were involved, while they were very able lawyers, were not famous in the sense that Clarence Darrow was, so that you didn't have that kind of long-standing attention to the case.
Yes, that's very interesting. You point out in your article that the representation of the defendants was not too bad. The lawyers were actually quite competent. Although there were things done in that trial which would never be done today. There were things done because it was the 1920s that would never be acceptable today.
Well, the lawyers provided, I think, very effective and zealous representation. It was interesting that I think there were 5 lawyers involved in the case. 4 of them were African American lawyers, and they really fought for their clients. I mean, I think one of the reasons was initially the investigation of the case was very heavy-handed, and it involved essentially rousting large groups of young black men, taking them to the police station and interrogating them for lengthy periods of time. It also involved taking the people who were and beating them, I should say. I mean, I don't think there's any doubt that the suspects, the defendants who were eventually charged, were severely beaten by the police. And then they were taken after they had made confessions to the police, and in the presence of some of the victims of the crime, the witnesses to the crime. They were taken to the scene of the crime, where they were sort of paraded out into the bank.
In a kind of reenactment.
They were asked to hold the weapons that were used during the crime, and to sort of step by step go through the crime as pictures were taken of them. And again, the people who were the identifying witnesses were present when this was being done, which of course reinforced their tendency to identify them as having been participants in the.
Let's just go through the basic facts of the case. How many people were killed? What were the circumstances?
There was a bank robbery of a bank on the near south side, 35th and Martin Luther King Drive, just east of where where Comiskey Park is right now. I should say U.S. Cellular Field or whatever they call it now. But it's just a block away from where the ballpark is. And the facts are that in the mid-morning a car drove up to the bank. 4 to 5 African American men emerged from the car, all carrying weapons, went into the bank, announced a holdup, and the bank guard, who was a retired African American police officer, pulled his gun and pointed it at the robbers, and in return, the robbers shot him. One of the robbers, or more of them, shot him and killed him. And the robbers then vaulted over the teller's window and scooped up money and ran. They were information was provided to the police about where a quote-unquote Negro robber's den would be located at approximately 3500 South on Wabash or so. And the police went there, and there were about 25 or 30 African American men, and they took them all to the police station. And in the process of interviewing them, they identified 5 or 6 people who they thought were the most likely suspects, and eventually got confessions from them.
Why was the crime the focus of so much attention at the time? Was there a large amount of money involved? Was there something notorious about it?
Well, I think for a couple of reasons. Number one, of course, an ex-Chicago police officer was killed in the robbery, and he was sort of a revered figure in his community. Number two, I think it was relatively unusual that a gang of African American robbers were organized to this extent to commit a crime like this. I mean, most of the bank robberies that had been committed prior to that, it's my understanding, were committed actually by whites. And so this, so that's the third thing, is that this was a crime committed in the African American community by African Americans, and it received a lot of press in the Defender.
The Defender, right.
The building itself, the building in which the bank was housed, also housed a number of African American professionals, dentists, lawyers, and actually some of the witnesses were those folks. And the African American community was very much outraged by this crime, and so of course the other part of, I mean, the reason for this was that these defendants four of them were eventually sentenced to death. There was a protracted appeal, and the execution process, or the legal process that led to the executions, was for those days quite protracted. I mean, it was about a year, but it wasn't, of course in ours, there's nothing compared to what goes on today, but that process of bringing those folks to execution received a lot of publicity.
And how many were actually executed?
4 were executed.
And where were the executions carried out? In the city of Chicago?
The executions actually were carried out in the basement of the existing Cook County jail at 26 in California. And the room in which they were executed is still there. There's no longer an electric chair there, but they were executed right there, and they were executed in a sort of a gallery down there where there was a chair and there were places for people to watch the execution. And the reports of the execution were quite gruesome. I mean, the chair was not a particularly humane way of killing people, and the people who witnessed it were quite shocked, horrified by what they saw.
Were there reports calling for the abolition of capital punishment after those executions, or for changes in the method of execution? Well,
before the executions, there were a number of church groups who got involved in trying to save these defendants' lives, and who petitioned the governor extensively for a pardon. So there was a lot of activity before the executions. Afterwards, there was not. I mean, there was just this, a continual campaign by people who opposed the death penalty, but not focused in particular on this case, because there were many executions after this case.
Of course, one of the interesting things about the history of capital punishment is you see these periodic rises and then falling of support for capital punishment over different periods. And at the turn of the century, for example, there was a period when support for capital punishment was very low. And if you look at methods of execution, it's also a very good indication of how people feel about the people who are being executed. So that in the Haymarket case, for example, they built a whole special apparatus for the execution of these defendants, which is a very good indication of how threatened the public was by these defendants. Now, what do you feel was different about the case then as opposed to the cases you deal with now?
Well, I think, first of all, there were a lot of procedural issues in the case that were similar to issues that come up in cases now, but those issues are handled very differently back then.
Like confessions?
Yeah, like confessions. I mean, I could go back, first of all, to the identification issue that I mentioned to you. I mean, we would no longer think it would be good practice to parade suspects before the people who are going to identify them at trial actually reenacting the crime. I mean, we know that that's suggestive. We have both in the case identifications that were made by African Americans and identifications that were made by white people. So we have the question of interracial identifications and the accuracy of those. We have in the case, the defendants who made statements claimed that they were beaten. and actually the lawyers, I think very creatively back then, filed a pretrial motion to suppress those statements. But when they filed the motion, they were told that they were not entitled to a hearing on the issue of the admissibility of the confessions prior to trial. The judge, as a matter of fact, remarked that he'd never heard of such a thing. It would be ridiculous to rule on the admissibility of the confession before trial. And so he allowed the prosecutor to refer to those statements in opening statement without ever having ruled on whether the statements would be admissible. But he did interrupt the trial to hold a hearing on the admissibility of the statements just before the statements themselves were introduced. And conducted a fairly lengthy hearing, actually, at which the defendants testified they were beaten and the police officers denied that they were beaten. And the judge, as I think is typical today, sided with the police officers, ruled that their testimony was more credible than that of the defendant. So the statements were eventually introduced.
What did you think of the quality of the judge? Was this a jury trial?
I thought the judge, for the most part, kept a sort of hands-off attitude, and he allowed the lawyers to do their work. He seemed to actually be quite an effective manager of the trial and to be on his toes. He was asked to do some things that, the issue that I just mentioned to you about the admissibility of the confession, which, if he thought the thing through, I think and with the benefit of a lot of, my hindsight, he should have said, let's do the pretrial hearing, but that just customarily wasn't done back then. So I thought he did a pretty good job.
So you didn't see anything outrageous in this particular judge's conduct? For example, the judge in the Haymarket trial has been criticized very much for the fact that his own behavior during the trial was so prejudiced against the defendant, and he conducted himself in a manner which was very inappropriate.
The only thing that this judge did that I found outrageous or bordering on prejudicial was really make a remark that I think he made by mistake, and that was when he was instructing the jury before trial. He told the jury that that if they were to find the defendants guilty, that he would have the option of that they could recommend a sentence, but he would have the option of not imposing the ultimate sentence if he didn't think it was justified. So the jury was, I think, lulled into a sort of sense of false security. They were allowed to think that if they found these guys guilty, that the judge could do something about what was then an automatic death penalty.
Right.
That the judge had the discretion to vacate the penalty part, but actually he did not have that discretion. So I think it's very likely that some of these jurors thought that well, even if we find him guilty, and even if they're initially sentenced to death, the judge can modify the sentence, but the judge actually had no power to do that.
Let's talk for a minute about how the death penalty was imposed then in the 20s, because it's different from our current death penalty jurisprudence. For example, now we have two separate trials, a penalty phase and a guilt phase. And I gather that at that time, when the jury came back with a verdict of guilty of murder, the sentence of death was automatic.
The jury signed two forms simultaneously. It was one form actually. There was a verdict form that said, we find the defendants guilty and fix the penalty at death. So one major difference between that trial and the trials we have now in death penalty cases is that the jury did not have the opportunity to consider any what we would call mitigating evidence at all about these defendants. Where they came from, who they were, what their family backgrounds were, whether they suffered from any mental or physical disabilities. Even the question of why they might have gotten involved in this case was really not explored by the jury. They had absolutely no information about these defendants before they imposed a sentence.
And there was no distinction made with regard to culpability as to who was the shooter and who was not the shooter.
Well, as far as the jury was concerned, no. I mean, there were both, one of the defendants who was sentenced to death was alleged by the state to be the shooter, but there were other defendants who were sentenced to death who were what we would call accountable simply by being there. And certainly they were all carrying guns. I mean, I think that there's no doubt that all of the people who entered the bank were carrying guns. Whether the people on trial were the people who entered the bank is another question.
I see.
But and then it turned out that that eventually it was determined that that a defendant who had gotten away initially and was not part of the original trial was the person who actually fired the shot that killed the prison guard. And he was brought back to Illinois from Mississippi, actually, from Jackson, Mississippi. They found him down there and tried sometime later on.
After the others were executed?
No, after the others were tried, but I think before they were executed. And he was not given the death sentence.
And why do you think that was? People had forgotten about the case, or for some other reason?
Well, you know, it's really hard to say. It's possible that that he may have provided or cooperated. He provided some information and cooperated. The other defendant who did not receive the death penalty was a guy named Melvin Jenkins, who claimed that he was sort of just along for the ride and that he didn't know anything about what happened. And he testified at trial, and really his testimony was really devastating to the other defendants. I think the record reflects that the state had some kind of secret deal with him to testify, and that the other defendants, the defense lawyer, were not alerted to that. Well, he got a natural life sentence, and he was eventually paroled. I think he was paroled in 1953 to Kansas City, and we actually traced we talked to his widow.
Yes, that's so amazing that you could do that.
Yeah, we found his widow in Kansas City. And it's interesting, she claimed not to, she was in her late 80s and very, very, very nice woman. But she claimed not to know very much about the case, really didn't want to talk about it. Her husband had died several years earlier.
What we're seeing in this case is similar to what we see in a number of present cases involving the death penalty. Circumstances similar to the Ford Heights 4 case, for example, or some of the other cases in which the death penalty was found to have been wrongfully imposed in Illinois in 2002. What do you see as the commonalities between the present day cases and this case from the 20s?
Well, I think certainly the reliance upon statements given to police.
Given under questionable circumstances.
Given under questionable circumstances is a common thread. And of course, one of the things that we're working on now is requiring the state to videotape interrogations. Back then, they could have made a movie of it. I assume that would have been a bit cumbersome back then. But certainly, they could have taken a verbatim transcript of the conversations between the police and these defendants. They had the ability. They had court reporting back then. Interestingly, what the prosecution and the police did back then that somewhat resembles the idea of videotaping is that they, at least when these defendants got ready to make statements, they had the defendants make the statements in front of an assembled group of distinguished citizens, some of whom were the professionals, the African American professionals who were in the building at the time that the robbery occurred. So that the way in which the state bolstered its claim that these confessions were voluntary was that they called these witnesses to the statement to testify at trial that these defendants were not coerced. Well, in fact, I think what happened was that the defendants were beaten and threatened and then brought out to make their statements before this audience of upstanding citizens.
Was that a common practice, that people were brought out to make these statements in front of some group of people who were acting as jurors or some sort of people who were evaluating the reliability of the statement?
I think it was highly unusual, actually. Highly unusual. I think that probably only in the most notorious cases was that kind of thing done. I mean, from what I know about the history of police conduct in conducting interrogations in Chicago, the department had a history of using the third degree to extract confessions. That's referenced in the Wigmore study.
Yes.
As a matter of fact, it's one of the elements of the criminal justice process that Wigmore decries, or that committee decried in that report. Yeah, I mean, making the remark that police were inclined to rely very heavily on statements that they extracted from people, as opposed to going out and conducting independent investigations. Well, that comment was, I think, certainly resonates with me when I of course look at what has gone on recently in Chicago, and then what went on back in 1929 in this case.
So what's shocking is not that these practices occurred in 1920 or 1929 or 1910, but they continue today.
Yeah, well, I think it is shocking. I think that that's one common thread. I mean, that's one common factor in the way that cases are tried. I think that in Cook County, we have a history of, as Wigmore points out, of relying on confessions to the exclusion of conducting a thorough investigation. I think the other interesting sort of common thread is that in accountability cases, which a lot of these defendants were found guilty as a result of their participation in the robbery as opposed to the actual shooting of the guard.
With regard to accountability, you mean the so-called felony murder rule?
We still rely on that very heavily, and yet it's an incredibly imprecise way of adjudicating a person's guilt or innocence.
What would be the difference between the rule for accountability in felony murder cases in 1929 and now?
I think it's essentially the same. I mean, there really hasn't been much of a change. The instructions, for example, that were given in this case, which we looked at, we found in the court file, were very similar to the instructions that you would give in an accountability case today. And yet we find, looking back at the trial, that there was probably a huge mistake made with respect to who actually fired the fatal shot, which would have been a critical factor in determining whether or who should receive the death penalty in this case.
What was the state of the records that were kept in this case, and how hard was it to find out the facts and circumstances of the case from newspapers of the time or the court records or anything else that was available?
Well, actually, the state of the records is really quite good. We found the actual transcript of the trial and the abstract of the trial in the state Supreme Court archives in Springfield. The actual transcript exists. It's a very brittle form so that it doesn't travel. And it could be microfilmed, but I think it's not on microfilm. We were able also to obtain what's called the abstract of record in the case, which is essentially a summary of the transcript that in the old days had to be submitted by the lawyers who represented the defendants on appeal. You had to both submit the transcript of the trial, and then you had to create a summary of the transcript. And so we had that document. We also had we got the Cook County court file, so that we had all of the orders that were entered in the case, and we had the motions that were filed.
So all of the official court records, such as the indictment, the motions filed, the sentence, the judgment, would still be in the Cook County clerk's office, but the transcript and that daily summary of the trial, the record of the trial, which the judges presumably relied upon, were in Springfield. Now, who paid for all of those transcript costs and things like that?
Well, in fact, the records in the criminal court reflect that the court paid for them. Mm-hmm. The lawyers were appointed to represent them, to represent these defendants. Mm-hmm. They were there are bills or requests for payment in the court file from both the lawyers and from the court reporters.
How much would the lawyers have gotten paid?
My recollection is that the lawyers in this case were paid maybe somewhere between $500 and $1,000 for the representation of these defendants, and it was at trial.
Did they continue to represent them on appeal?
Yes, they did. Uh-huh. Yeah, and they made heroic efforts on the part of these defendants. Mm-hmm. One of the interesting things that they did was to claim that these defendants, as they approached execution, were incompetent to be executed, that their mental state had deteriorated to the extent that they were not, quote unquote, competent to be executed, because there was some good law on that. You can't execute someone who suffers from a severe mental disease.
Another issue which is still very much with us today, the only change being today that the question arises whether or not you give somebody psychotropic medication to make them temporarily competent to be executed.
I mean, there have been some very recent Supreme Court cases that have dealt with that issue, and retardation and mental competence.
Very interesting.
Yeah, and I think that, in fact, I mean, it's not clear to me to the extent to which these defendants were actually incompetent or, quote, as the word back then was, insane. Yes. but it was the only avenue really open to these lawyers to keep these folks from being executed.
Were there extensive clemency petitions made to the governor?
Yes, there were, and there were some hearings. What is, I think, very interesting, again, and that it resonates with me now, is that when it came to light that one of the folks who was going to be executed was reputed to be, the state's theory was that he was the actual shooter. In his clemency petition, he alleged that in fact it had been established, and the state was asserting in another case that another fellow was the shooter, the fellow who had been apprehended later. The state continued to take inconsistent positions on this, even at the clemency stage, and was asserting that in the clemency hearing that the person who everybody admitted had not fired the shots was the person who fired the shots.
So this is another example of an issue we see today. There was just recently a case in Florida, I believe, where the prosecution tried to allege in 2 separate cases that a different person was the shooter. And, you know, in one case they said it was X, and another case they said it was Y.
Right. I think the convictions were reversed or vacated,
Right.
but I think the most recent case involved the question of whether the lawyer should be disciplined for taking. And you're right. The disciplinary authority in Florida decided not to discipline the lawyer.
What surprised you about this case, and what did you bring back from this case to the work that you do today?
Well, I think first of all, I was impressed with the quality of lawyering on both sides. Actually, the prosecutors were extremely articulate and able, and I hadn't expected to see the zealousness of representation that these defendants received from members of the private bar, and the skill that they used. I was also surprised by the public outcry against the death penalty, and the fact that and the clemency petitions that were filed that were very, reminiscent of cases that I'm aware of that have occurred within the last 20 years in Illinois. That this is sort of a long tradition of opposition to the death penalty, and that the people who have been opposed to the death penalty were making some of the same arguments then that they're making now. And of course, in the case of the fellow who was executed, who was alleged to have been the shooter but was not, there were really claims of innocence made on his behalf that are very reminiscent of the claims that we hear today.
One of the things that strikes me as I read your article and listen to you talk about this case is the high quality of professionalism on everybody's part, even though there's some procedural things that would be done differently. And, there are no real devils or, evil people here. And yet the system just grinds on, and these people end up being executed, and that's the way it is.
Yeah, I think that's very true. And I think the other thing that struck me was that the prosecutors in this case were actually, I think in some ways used the case for their own political advancement. The names of the prosecutors, and I'm just drawing a blank right now on their names, but one of them became a very prominent criminal defense lawyer and actually wound up being opposed to the death penalty.
White or black?
White. The other prosecutor, who was a graduate of Northwestern, wound up being a senator from Illinois later on in the late 40s, early 50s. And I'm just having a senior moment here, and we'll get the names out in a minute. But I think it's very interesting that that typically these cases are used to advance the careers of the people involved in them, and that was certainly something that was certainly part of this scenario.
Of course, we see that today as well, that state prosecutors run for political office on the basis of how many people they've executed, and what better way to advance your political campaign than to have your name and picture in the newspaper every day at a celebrated murder trial against some very unattractive defendant. So that hasn't changed either. But I'm very interested in the role of the newspaper, The Defender, which was the leading African-American newspaper of the time. What attitude did they take toward this case? Did they take the attitude that the defendants wouldn't have been sentenced to death if they had not been African-American?
It's interesting that the attitude was really very, I think, at the initial stages of the prosecution, very pro-prosecution. As I mentioned before, the victim of the crime was a fine, upstanding member of the black community, a decorated police officer who had retired. The location of the crime was, in the black community. The black community, just based on what I could read in the newspapers, was not particularly was angry about the fact that this crime den existed within the community. As the case progressed to the punishment stage, however, my reading of the newspaper is that and questions began to be raised about the degree of the individual defendant's involvement. The newspaper began to be a little bit more skeptical about the penalty part of it. And as a matter of fact, when the final execution was completed, there was an article in the Defender which raised these issues that I've mentioned before about whether the person who was last executed was really guilty of the crime and whether we should be imposing this kind of sentence. So it started out very pro-prosecution.
And what was the time between conviction and the execution of the defendants?
About 18 months.
Yeah. We can only guess at what people's attitudes were towards violence at the time by reading the newspapers or looking at accounts of people who were alive then. We can only approximate what people thought. But I was shocked, absolutely shocked, to read in the Illinois Crime Survey that during the beer wars, for example, there were 100 bombings a year. That's like one every few days. I mean, we would never tolerate that.
There was not only, that going on at the same time that this trial was going on, and but there was also the fact that not only were there these random and organized acts of violence, but the perception was that the existing criminal justice system was not equipped to deal with those cases because of its links to organized crime. And I think that's the reason why we had the Illinois Crime Survey. That was the genesis of the creation of this committee of upstanding citizens who recognized that the city could not exist as a viable economic unit and that its reputation was being ruined by this kind of conduct. And yet the courts were not dealing with it at all. These cases were, if you followed those bombing cases, for example, if anybody was ever caught, you'd find that either the case got lost somewhere in the system, or a person got some kind of a sweet deal without ever being indicted. So that's the reason, that's the genesis of the crime survey.
When you look at the Illinois Crime Survey, it's really extraordinary the seriousness and thoroughness of their report on the criminal justice system in Illinois at the time, and particularly the role of organized crime and the participation of organized crime. The crime survey was initially started in 1924 when there was a reform mayor who was elected. Then he was kicked out, and it's to the credit of the people who were involved that the crime survey wasn't stopped. It did finally publish its findings in a very large report in 1929.
I think it's interesting also that at that same time, this was part of a national movement in criminal justice reform. There had been similar surveys conducted, I think, in St. Louis and in New York and Boston.
This is the most comprehensive one.
In my review of it, I think this is the most comprehensive report on a justice system that I've seen.
The Illinois Crime Survey, which was published in 1929, compares very favorably with similar work which is being done today. And I think that's partly because of the involvement of a number of distinguished academics, such as John Henry Wigmore, who was dean of the Northwestern Law School at the time, but also just the quality of the researchers, such as John Landesco, who did the reports on the organized crime section. This was just very high quality work. I
think another astonishing part of this is that for those of us who've tried to conduct similar studies, and to obtain, the information that you need to do that from the court system.
Yes.
It's very difficult now to do that. As a matter of fact, if you were to go in and say, I want to do this kind of study, I want this information from the court system,
Right.
I want this from probation, I want this from corrections. I mean, because they covered all of that. They covered
did.
every aspect of
They
the
did.
criminal justice system.
Right.
You'd find a lot of roadblocks. And to me, one of the most interesting parts of that study is the fact that this group was able to obtain all that information, which suggests to me that everybody involved viewed reform of the criminal justice system as a real priority, in part because of the factor that that you just mentioned, the fact that it was in such disarray as a result of its ties to organized crime. That I wish we had that kind of open. That kind of access to information now. That's one of the things we really have to work on. We don't have that right now with our existing administrators of the criminal justice system.
That's true. The 1915's Chicago City Council report, too, that the access to information is across the boards. Now, partly perhaps that's because of privacy concerns.
I don't think there are any privacy concerns at all. I think it's a political issue. I think that there is, first of all, the court is relatively disorganized in terms of its record-keeping abilities and conduct.
Right.
Second, there are so many different fiefdoms within the court system that are so protective that it's hard to get at the information.
Of course, it serves somebody's political purposes to be disorganized. It protects the bureaucracy if they don't have anything which shows how they're doing their job. If you have 1,000 little bits of tiny information so that it's a huge effort to put that information together, then nobody will ever know what you're doing.
Right now, we are, with the Chicago Council of Lawyers, Northwestern, maybe the American Bar Foundation, are thinking about conducting. We've got some money actually to conduct a study like the Wigmore crime survey. But one of the problems is, well, how do we approach the chief judge? How do we approach the state's attorney's office? How do we approach the public defender to get the information that we need? Because we're going to be perceived as going after somebody, or the people we're talking to are just not going to be willing to give us the information because they've got something that they don't want revealed, even though these are public bodies.
Tell us what you want to study and what you want to look at in the report you're planning for today.
Well, what we want to do is take a look at lawyering in the criminal justice system, and we want to examine the operation of the judiciary, the public defender's office, which is a 600+ member lawyer office, and the Cook County State's Attorney's office, which is probably even a little larger than the public defender's office. And we want to see how they're functioning. Are they functioning efficiently? Are they hiring the best people that they can hire? Do they have too many or too few cases? Ultimately, we're concerned about whether the operation of the judiciary, the State's Attorney's Office, public defender, are contributing to the fair and efficient administration of justice. That's the same thing that the Crime Commission the crime survey was interested in.
One exception to what seems to be the current inability to produce a meaningful and serious report is Governor Ryan's commission report in 2002. That was really a high-quality enterprise. It had excellent staff, it contained meaningful statistics, it addressed important problems, it was very comprehensive, and that was really very unusual. I think what Chicago and Illinois are harmed in this respect by the fact that the Illinois Supreme Court doesn't sit in Chicago and hasn't carried that authority or weight that some other state Supreme Courts have.
Well, in Illinois, we unfortunately don't have that tradition. As a matter of fact, I think our Supreme Court has been far too hands-off in the supervision of the lower courts, particularly those in Cook County, and has not been willing to commission thorough studies of what's going on in the court system. So it has really failed, in my mind, my view, to exercise the kind of leadership that we need. It's been more of a protector of the status quo than of a progressive force. I'm hopeful that there are some new members of the court, and even some people who have been there for a while who might. I view, for example, Justice Fitzgerald as someone who might take a lead in taking a look at something like this. I think he's very bright and very committed. I've been impressed with his work in judicial education and the death penalty. He's been he's played a great leadership role. But the difference between, you mentioned the Governor's Commission and what we need in looking at the entire justice system is that commission, the Ryan Commission, was able to conduct an investigation without getting access to the kinds of records. I mean, you could read trial transcripts, you could take a look at reported cases and use that data to make the recommendations that commission made, which are wonderful. Yeah. But what I'm talking about is a more in-depth look, an ongoing look at what the system, how the system is actually performing. Exactly. That's a lot different.
And it's much needed.
Oh, it's
so needed.
Very needed. I mean, I think that we could reduce the incidence of wrongful conviction substantially if we took a look at it. We could establish priorities in terms of what kinds of cases do we really need to be worried about. Does existing sentencing policy make sense? I mean, all of these questions are questions that we're just not. We just don't have the capacity right now to look at objectively.